Settling or dissolving a trust in the legal world is what we refer to as trust administration. So we rarely, as lawyers, use the word dissolving a trust, but we understand that sometimes that has been like a keyword or a search word that some of you may use when you're trying to figure out, okay, what do I do now? Someone in my life has passed away. I have this trust. What do I do? So that's what we're going to be covering today. Here are a few things that we're going to be covering throughout today's webinar. What, if anything, needs to be done when, with someone's trust after they pass away? How badly can things go? How are we going to avoid mistakes? Who is in charge? When can people get their inheritance? This is a huge question that we get, when people call in and think that everything can be done so quickly. Everyone's asking me, when am I going to get my inheritance? And so we're going to talk about that more in depth. What about taxes? Taxes are also a really big question, a topic that most people are concerned about. Can this process be done without hiring an attorney? And if you do need to hire an attorney, how does it work? So these are a few of the things we're going to touch on, really the key aspects of how to administer or dissolve a trust. We're going to also cover some common pitfalls that we see come through the office or that people do make. So introducing myself, I'm Rochelle Lee Warner. I'm a partner at Cunningham Legal. I've been with the firm for several years, and I'm licensed in California, Missouri, and Virginia. I have been working exclusively in trust administration and probate and estate planning for over 10 years, but I've been an attorney for almost 20. I went to the University of San Diego School of Law, and in general, our firm handles several different areas. So not only do we work through trust administration and probate, which we're going to focus heavily on today, we also assist clients with foundational and advanced estate planning work, tax planning, and business and real estate law. And we have a wonderful team here at Cunningham Legal, and these lovely faces on this screen are the attorneys. You've got Jim Cunningham front and center. He's the owner. You usually hear him speaking. You've also got Tasha John, a partner, and we've got a great team of attorneys here that are all fabulous to work with. And I have to share this disclaimer that today I am talking to you as an attorney, but I am not your attorney. So anything that I'm sharing may not be for your situation. So please do not watch this and then decide, hey, I'm going to go do exactly what Rochelle said today. No, I need to know the specifics, or any attorney working with you needs to know your specific situation to be able to help you. So let's get going into the topic. 5 big steps in settling and dissolving, or as I mentioned earlier, for some of you just now joining, we refer to this as trust administration, or administering a living trust after someone passes away. So these are the 5 kind of key steps that we're focusing on today. And this is the overview. We're going to get into these into a little bit more detail in the coming slides. But first, we're identifying the terms of the trust. So most people would recognize that you have one trust, that maybe that's all that there is. But sometimes there's additional documents that we call amendments that add on to the trust and are a part of the entire document. And then there's a restatement. A restatement basically takes the original trust and any amendments thereafter and supersedes them. So you're going to bypass everything that was prior to the restatement and just work off of a restatement. We as attorneys really have a preference for restatements because they're clean. You're working off of one document. And so we're going to talk about that a little bit more. But basically, identifying the terms of the trust depend on what trust documents we have to work with. And then identifying the trustee. So the trustee, you're going to hear sometimes personal representative. They're not exactly interchangeable, but I would say that sometimes we hear institutions ask, like, who's the personal representative? And a lot of times that is going to be the same person, but sometimes they have different functions. So the trustee, we have to know who that person is. They are the one in charge. They're managing. They have the power to take action and take control of the assets, which is the next big step. Trustee has to take control of all of the assets. And one of the big issues we see is just identifying the assets. If you have a trust set up and you haven't been very clear or given great direction to your trustee about what your assets are, then their first step is putting the pieces of the puzzle together and figuring out what all assets we're looking at. Are we looking at property, bank accounts, brokerage accounts? You name it. There's assets all over the place. And we're going to talk about that a little bit more about how we make sure to make that nice and easy for our trustee. Sometimes there's assets that aren't in your trust, but they should be. And we have a process for helping identify those. But we also need to know the assets that aren't titled to the trust or part of the trust. So really understanding the entire estate is part of the trustee's job. And then we're going to wind up the affairs of the decedent. And that is going to mean we're going to look at the probate code. You're likely working with an attorney. You have to go by what rules there are in California to actually administer or wind up this trust. And a lot of that has to do with giving proper notices, paying debts, taxes, paying the expenses of the estate. And then finally, distribution. Everyone's always interested in the distribution portion, so we've got some keys that we need to talk about there. But basically, that is when everyone is able to get their piece of the trust, whether that's property, money, you name it. So let's go back to basics before we dive into how to administer the trust. What is a living trust? So think of the trust as a bucket that you are putting your assets into. And the trustee is going to be the one managing or holding the handle of that bucket. They are the ones that are able to put assets into the trust and take assets out or manage and control them. And when a trustee stops being a trustee, then the bucket's going to pass to a successor trustee who's going to oversee the entire trust. And again, that trustee has to work with the probate code because there are rules that they have to follow for the whole process. Usually the trustee, when someone is alive and they put together their trust, usually the person who creates the trust is the trustee, not always, but most of the time. And then the successor trustee steps in either when someone, decides to step down, they get sick or incapacitated, or at death. And what are some benefits of the trust? The main benefit is you're avoiding probate court. Probate court is expensive and it takes a lot of time. Usually it's going to take up to 2 years to get through an estate in a California probate. It's also expensive, usually more so than going through a trust administration because there's a statutory fee that gets paid out to not only the executor of the estate, but the attorney that's helping with that probate. So a lot of money is going out the door right away when you have a probate. The trust also provides you with privacy so that you are likely avoiding a court. You're not filing this trust so that everyone can see it. And we can also put provisions in trust sometimes to help minimize taxes for future generations. Other benefits can be protection for the inheritance and those beneficiaries. If they have any creditors or divorce situations, predators, we like to be able to protect those beneficiaries in those situations. And so again, going through the trust process is going to be most of the time a much smoother and less expensive process than just going through a probate. So, why do people use a living trust? Sometimes it is for just strictly estate planning, making sure that your assets are going to go to who you want them to go to. Sometimes it can be for tax planning and asset protection. As I touched on earlier, if you have someone in your life that you care about and you want to give them some of your estate, but you're concerned about how they'll manage it, we have ways to be able to help them in the trust manage that inheritance. It protects them, it protects your assets. And so, trusts are very useful tools for that. Also, to avoid probate, as we touched on, protect your legacy for your loved ones, minimize taxes, and really at the core of the plan for most people is just the peace of mind that you took the action, you put in a little bit of work, but everything is set how you want it to be when you pass away. So the key players also are important in a trust. So we have a term called a successor trustee. Any of you who have a trust most likely know what this is, but I want to go over it briefly because they are a big part of this conversation today. So a trustee is going to be the person who is managing, or here's this word again, administering the trust. And they have a fiduciary duty to do the job well, and they're accountable to beneficiaries. So they're stepping in this management role. Sometimes it's during the creator's life, and so they're managing for that creator and taking care of them. And then upon death, they're managing temporarily or sometimes long term for a beneficiary who's receiving part of the inheritance. A trustee has to be a human with a heartbeat. It could be a family member, it could be a friend, a trusted individual. Sometimes it's a professional. There are professional fiduciaries or trust officers that do this for a living, and we have many clients who actually prefer to have a professional fiduciary managing things for them when they pass away. Responsibilities include following the terms of the trust as they are written in your trust document. They have to marshal and manage the trust assets, and they have to follow applicable statutes, case law, doctrine, really, focused on the probate code in California. There's a lot of duties, there's a lot of regulation around being a trustee. They also have to communicate with the beneficiaries or those who are inheriting and others, like different individuals at institutions when they're trying to gather asset information. So when we're working with trustees, a lot of times we're communicating with beneficiaries on a formal basis, but our trustees are communicating with beneficiaries on an informal basis and just keeping them aware of what's going on, what to expect. Really that big question I alluded to earlier, when am I going to get my inheritance? The trustees have to field those types of questions. And so with the trustee role as well, you've got ownership versus control, rights versus duties. This is really important because I think a lot of people get confused in the role of who does what in a trust. So a trust always has three parties. You've got the trustor or the creator, you've got the trustee, and you have a beneficiary. And a lot of times during your life, if you're creating a revocable living trust, the trustor, trustee, lifetime beneficiary can be the same people. But that typically changes when someone passes away. So the trustor passes away, and then you have your trustee come into place. They are controlling, they are managing, but they are doing so for the benefit of these beneficiaries. And the beneficiaries have rights. So you've got to look at it as this trustee has a job and they are working for the beneficiaries. The beneficiaries have a lot of power, and sometimes they can be a little annoying or abuse that power. And I apologize to any of you who are beneficiaries out there that have been in that situation. But really, the trustee is trying to get through this process of administering the trust for the benefit of the beneficiaries to make sure that they get the accurate inheritance and take care of all of the duties so that that estate is ready to distribute. And sometimes the trustee is also a beneficiary. So, they're not only working for others, but eventually, for their own inheritance as well. And they have to be impartial and be thinking about everyone else's rights. So now let's get into the 5 steps in dissolving a living trust. Step 1, identify the terms of the living trust. So most, revocable trusts are going to be revocable, amenable during the lifetime of that grantor creator. And you can see in a lot of instances that you'll have amendments come into to play. So let's say, here's our example. Abel creates a living trust in 2010. He amends the trust in 2014, 2018, 22, 24. That's a lot of amendments. Which terms control? Well, in this situation, I would say you want to go to an attorney because it can get really confusing. You're looking at 5 documents in this case, and you've probably got some different provisions that have changed over time. And then at the end, you're like, what do I have here? Sometimes this requires an abstract of trust or an interpretation of really what pieces of each of these amendments work together to tell me what to do or who are the beneficiaries and what are they getting. So when you have amendments, and we have seen clients, that have multiple amendments, more than 4, that come in, and it can be very confusing. And I would say a lot of times those types of matters end up in court, and the judge is telling us the terms of the trust. So we love restatements. I mentioned that before. But in our example with Baker, he creates his living trust in 2010. And again, he amends it in 14, 18, and 2022. But in 2024, instead of an amendment, he restates the trust. Well, in this case, which terms control? We are looking exclusively at the restatement in 2024. We don't have to look at those documents that were executed in the earlier years. That restatement in 2024 is going to control. It's going to tell us who the trustee is, who the beneficiaries are, what everybody is receiving, how to run this trust administration. So you've got to be careful when you identify, first of all, which documents there are and which ones control. And then we have to identify the key players. The trustee, again, is usually going to be named and pretty easily identified in a trust. But again, if you have multiple amendments, it may be difficult to figure out who that trustee is. And so the way that we prove that up is we prepare a certificate of trust, and that trustee then has a document to show, I am the person that was named to be managing this trust, and here's my proof. Personal representative, a lot of times you're going to hear personal representative, when you're going to an institution or working on taxes. Again, it's usually the same person, but they're the one who is able to communicate and make decisions on behalf of the estate. So here's some examples too of ways that the trustee could be a little bit unclear. Charlie names Delta as successor trustee, but Delta is deceased when Charlie dies. So who's the trustee? Well, in this case, I don't have any further information, but if I don't have anyone named after Delta, I don't have a trustee. We would likely have to go to court to get someone appointed. Now, what we like to see is we have 1 or 2 backup trustees. So maybe after Delta, we'd have, Ernie, and then we have Fred. And that way we have other people who can step into that role. In the second example, Charlie's living trust directs Charlie's estate to be distributed to Delta, who again has passed away. Who are the beneficiaries? Well, we would like to see a little bit more clarification on what happens if one of the beneficiary passes away. And a lot of times we will see, okay, if Delta has passed passed away, then it's going to go to Delta's children. And if Delta doesn't have children, it's going to go to, Charlie's sister. Something like that is going to make it a lot clearer and easier to figure out where these assets are going to go now. And then in our third example, India's living trust directs the trustee to distribute trust assets to India's then living issue. Who are they? Again, we don't have a name in this situation. We have a category or a group of who the beneficiaries are. And that means the trustee is going to have to figure out who those people are now living that are India's issue. Sometimes you'll see descendants. There's varying phrases that you will see, but if we don't have direction for after someone like a trustee or a beneficiary passes away, it can get really tricky. So working with an attorney through this part is very helpful. Now you're going to see a lot of names depending on the type of trust and who drafted your trust in the process. And so grantor, I've mentioned this before, it's the same as the creator, the trustor, settlor. You're going to see those words more commonly in trusts in the United States. But you're also going to see some of these other words listed here: founder, principal, trust creator, establisher, trust maker. I've seen that a few times. And that's going to identify who has actually created the trust. Key players in the trust administration process are also beneficiaries. We talked a little bit about this earlier, but the beneficiary could be named directly, very specifically is best practice. They could also be described, as our example before with India's issue. Now we have Romeo's issue. It could be issue, descendants, and we have to sometimes look at the probate code as to what those definitions mean. Issue would be, the children. And then are we going to include a grandchild of a child that's predeceased? All of those types of direction terms are part of the trust document and have to have interpretation. And then here's a combination. If Sierra is predeceased, what does Sarah's issue mean? Well, it likely means for children, but what if Sarah doesn't have children? What are we going to go back to? And then we have the question of if Sarah survives Romeo and Romeo created the trust, but Sarah does not survive through the complete distribution of the trust, what happens to Sarah's share? And that again is likely going to be dependent upon what the trust says. And sometimes we have to look at the probate code. So you could have a situation where Sarah survives 20 days after Romeo and Sarah doesn't end up getting that inheritance. It's going to pass to the next person. Or potentially Sarah survives for a while and she hasn't received her inheritance, and then she passes away and everything is going to go to her estate, which would either trigger a probate of her estate or potentially it's going to be able to go through her trust. So it gets really complicated here, and making sure that you understand as the trustee who the beneficiaries are and how all it could go down the line to someone is important, because if you're the trustee and you're paying out to a beneficiary that isn't truly a beneficiary, then you're going to be liable for that. Now, step 3, inventory of the trust assets. So I mentioned earlier that identifying the trust assets is a huge part of the trust administration process. Not only are we looking at assets that are in the name of the trust, but we also have to just identify all the assets that someone owns. So I want to emphasize the importance here of making sure for any of you that have your trust and have assets that aren't titled to your trust, that you need to take the action to do that and make sure that it's the appropriate assets that are part of your trust. That is something we can absolutely help you with, because it does get complicated. It can be tricky to figure out exactly which assets should be titled to my trust and which assets should I have a beneficiary on. We can help you with that. I will say that I have seen people who have their trust document and they have their schedule A on the back or schedule of assets, and they have 10 assets listed on there, and maybe two of those assets have truly been transferred or titled to their trust. Well, what happens then? So if that person passes away and they don't have all of those assets that they listed on their trust as part of their trust, it's likely going to open us up to a probate. So you have to be very careful and make sure that not only have you created your trust, but you have funded your trust. You have retitled assets that need to be part of your trust to your trust. And we provide an example here, but it would be, to title your property to your trust would be Able, trustee of the Able Trust, dated January 30th, 2010. If you don't know exactly how to do that, we would be able to help you. Just give us a call, especially if you have a trust with us. You have a document called a certification of trust that tells you exactly how your assets should be titled, and we can point you to that. Now, identifying assets that should be in the trust but aren't. Again, anything that is not in your trust and does not have a beneficiary is likely going to some form of probate. And here's an example. Abel never signed his deed to his house or recorded it with the county recorder's office. So that means that property is probably still in just Abel's name, not in his trust. We're going to go to probate for that. Now, here are some assets that, should be part of your trust. And this is not an exhaustive list, so we need to, again, talk through with an attorney what assets of yours should be in a trust. But bank accounts, investment accounts, stocks, bonds, real estate, membership interest in an LLC, that that can be a little confusing for people because you might own a portion of a business and you have an interest, a certificate that might be in your name. Well, you need to work with us to make sure you get that into your trust. S corporation stock, we also have to be careful there because your trust needs to have terms that enable your trustee to manage that S corp stock as well after you pass away. Personal property, we don't usually retitle it to a trust, but it's incorporated in through a general assignment, meaning, everything you have in your house, jewelry, things like that, are going to be considered part of your trust with a general assignment. I will also touch on cash because I've had that question, every so often from a trustee. Well, they had a whole bunch of cash hidden away somewhere. Well, that should be part of the trust and distributed among the beneficiaries of the trust. The trustee should not ever take that, as to go to someone else. Automobiles, typically in California, we can go through a process where we can, use the DMV forms. There's a little bit of a holding period there, but we don't usually retitle those to the trust. And then some assets that should not be in your trust that are better off to have a beneficiary designated: IRAs, 401k, your retirement plans, annuities, life insurance. I'd say the main reason for that is because of tax consequences when you have the trust named as the beneficiary, or you have the trust, have these titled to your trust. Life insurance, we do sometimes see go to the trust. So the important thing, again, is make sure they're either part of your trust or that they have a beneficiary designation. And we have to remember that when we're looking at the entirety of the estate, we are not only including the trust assets, but we're including all the assets owned to value the estate. And the reason we have to value the estate is because we want to make sure that if it's large enough, that we pay the appropriate estate taxes. And so depending on the year it is, you've got an estate tax threshold. And if your estate is over that amount, you're going to owe taxes to the IRS. Taxpayer identification number. This is one of the big topics that people call in about. EIN number, TIN number, you'll hear that interchangeably. But one of the first things you have to do as a trustee is apply for this tax identification number. You can no longer use the creator or the grantor's social security number to be the identifying number for the trust. You have to have a new number to replace it, which is called the EIN. And I highly recommend that you or your CPA, I'm sorry, the CPA or your lawyer gets it. If you get it, I have seen many people come to us because there's been a problem in the way that they filled out the application, and then we have to fix it. So, again, highly recommend that a CPA or lawyer help you with that. And you only need to get one for the trust. If there's multiple trusts, you get one for each trust. But again, speaking with one of us about that would be crucial. Death certificates, how many should I get? So usually this is one of the first steps that a mortuary funeral home will help you with in putting together, the order for the death certificates. I think the general number is 10. I actually have seen people get fewer just because most institutions will take a copy, and you need an original when you are recording for real property. So if Abel died owning 5 condominiums, the trustee would order 15 death certificates. 5, because you need 5 originals for each of those properties, and then you have the 10 extra. But definitely one for each of the real properties that the decedent owned. And then another big step for the inventory is really getting that adjusted cost basis at death. This is huge because if you are working with a brokerage account and you have somebody who's had this, account for many, many years, their basis in the account is likely very different than what it would be when they pass away. And so that brokerage firm has to what we call step up or adjust the cost basis to the date of death valuation. And this helps prevent capital gains taxes when either they're liquidated, sold, and that's going to only benefit the beneficiaries. And if the trustee doesn't get that right, there's a lot of liability there. So this will apply to investment accounts, real estate, stocks, bonds, mutual funds, partnership interests, personal property. That's why we say you need to get an appraisal for real property that's going to be kept for a while, because we want to get that new value. And here's our example. India pays $100,000 for her home. And when India dies, Living Trust owns the home and it's worth $1 million. Now, when Juliet inherits the home, Juliet sells the home for $1 million and avoids the capital gains tax. That's because the valuation at the time of inheritance is the same as the sale price. So there's no capital gains tax. If we didn't have that adjusted tax basis, then there would be a really significant capital gains tax that taxes are owed on. And then we have notices. So you're going to hear, if you meet with any of the trust administration attorneys here, you're going to hear the California Probate Code section 16061.7 notice. This notice has to be sent out when a trust becomes irrevocable. And it should be sent out within 60 days of a grantor's death. That doesn't always happen just because sometimes the trustees don't come to meet with us that early. But it does need to get sent out to the beneficiaries who are named in the trust and also the legal heirs. And again, this part can be really tricky because if you don't get the right people the notice, you could open up the trust to liability. Reason being is that this notice cuts off the rights to contest or challenge the trust within 120 days of that notice being sent. So if you forgot to send it to somebody and you get through the 120 days and think you're in the clear, but then this person decides they want to contest the trust, they still have the right to do that because they weren't legally notified about the trust. So you think as a trustee, you're ready to go, you're ready to distribute everything, but there was someone left off the notice. So this is another important task that having an attorney's assistance with is highly recommended. It has to be written in a certain way. It has to be sent by mail. You can't just, drop it off at the neighbor's house or email your sister. It has to be done in a certain way. And a copy of the trust document is almost always recommended to be sent with that notice. Typically served again by U.S. mail to the last known address. This does come up sometimes. You'll have someone who's listed as a beneficiary, or potentially even, a close family member that you don't know exactly how to get a hold of. Maybe they've decided to be very private about their where they live, or maybe even they're homeless. There's a lot of situations where we have an issue of, okay, how are we going to get this to someone? We can help you with that. But really, the rule is mailing it to the last known address is going to be sufficient. And we can do our best to search and figure out where that is. But when we exhaust those resources, getting it to the last known address will suffice. What the notice has to contain is listed here. We've got to identify the creator of the trust. We have to provide the trustee's information. We have to give the address of where the trust is administered. Sometimes that's the lawyer's office, sometimes that's the trustee's address, and that the person receiving this notice is also entitled to a copy of the trust terms. One of the main reasons that we go ahead and give the trust terms when we send the notice is because we can lock in that 120-day notice period when we do so. If you don't provide the trust and then a beneficiary or heir requests the trust, that can extend that contest period, and that just delays everything. So we usually do send the trust. Next thing we have to talk about is the real property. So a lot of times we are going to be working with trusts that own real property, probably at least a residence. Sometimes there's other investment property, and there will be requirements for the trustee to take with the real property. One of the first being that an affidavit is going to be recorded at the county to indicate that that original trustee is no longer living and that a successor trustee is in their place. And this allows that successor trustee to be able to have control to do what they need to do with the property. If it's going to be sold, if it's going to be kept and distributed to a beneficiary, we have to get that successor trustee on title. And again, this requires a death certificate and also assessor forms to be filed with it. Remember, with real estate in California, death is a change in ownership. And so with a change in ownership, that triggers reassessment. There are some exceptions, but for the most part, as of the date of death, there's going to be a change in ownership and a reassessment. There will be a supplemental tax bill. The trust is responsible for paying that tax bill. And so you've got to have, a buffer there to be able to work with to pay that additional cost. Notice of change of ownership when there is entities involved is filed with the Board of Equalization. And so this can get tricky too, because sometimes people don't realize that if there's an LLC, for example, that there's needs to be a step taken. And if you don't get the appropriate documents filed with the Board of Equalization or the BOE, there can be really large penalties and assessments on that property. And again, this kind of talks a little bit more about that. There is a deadline to get that filed within 90 days of the change in control or change of ownership in a legal entity. So this is a really serious deadline to pay attention to if you're a trustee for someone that has a business interest. Now, debts are interesting in California because when you have a probate open, there is a requirement to notify creditors of the estate. But in California, there's no requirement to notify creditors for a trust. Sometimes you're going to know about outstanding bills. You get them in the mail and you see that, someone's passed away and they still have these medical bills or some credit card bills to take care of. Those are things that you're going to want to talk to us about to determine, are these debts, ones I have to pay for the trust, and what makes sense here. So again, probate, you have to notify creditors. Trusts, it's a little bit different, and there's not a required notice that goes out. But when those debts and bills do come in, we do want to review them and give you advice. Also, really important is to keep really detailed records of all the expenses paid from the trust. Eventually, an accounting would probably go out to the beneficiaries, and they need to see what all has had to be paid out on behalf of the trust. And some expenses are going to be allocated to a specific beneficiary, others are not. So this is really important again for keeping those accurate records. And here's an example. If Abel leaves Redacre to Charlie, the expenses of Redacre are chargeable against the income from Redacre and not to the trust overall. So when there is a specific gift of a property, unless there are details in the trust that say otherwise, the income and the expenses of that property are really for that beneficiary. And during that kind of time you're going through the administration and the settling of the trust, you need to keep track of those because they need to get allocated to the right person at the end of the administration. Pecuniary gifts or specific dollar amount gifts do need to be paid within a year of the date of death. Otherwise, they start accruing interest. And then moving on to taxes. So taxes are a huge part of trust administration. You, as the trustee, will be responsible for filing tax returns. So you're usually going to have a part of the year that there's the personal income tax return due. That's going to be what they've done all their life with their social security number. You've likely got a part year return there. And then from date of death forward until that trust is settled, you've got a trust tax return. And if there's sufficient income come from that trust, you're going to have to file a Form 1041 to show the income of the trust and pay taxes on that. Sometimes there is estate tax. Again, that's going to depend on the year that the person passed away, the size of the estate. There's a lot of factors that go into that, potentially gifts they made during their lifetime. And we need to assess whether an estate tax return or a Form 706 is required, and then determine whether there are any other state liabilities, local filings that are required when someone passes away. Now, I can't emphasize enough how important recording your actions are as a trustee. So you need to document all your actions. Anytime, again, you were paying out funds to the debtors, to beneficiaries, all the payments, upkeep on the house, the property taxes, the insurance, you name it. You need to keep track of that. Usually statements are a good place to start. And if you need to add some notes on those bank statements as to more detail, then please do so. And then you're going to provide beneficiaries with a final accounting of the trust activities. And what this looks like is it's going to show a starting point of inventory of the assets from date of death, and then all of the income, all of the expenses through the administration until the assets are ready to be distributed. And then we also like to provide receipts when it's time to distribute so that that beneficiary can see, this is the amount that I'm getting. Maybe it's, going to be in a couple of disbursements, but at least we're going to give a receipt, have them sign that this is what they are to receive. And then once all of the distributions and obligations are met, you would be able to close that trust. Distribution of trust assets to beneficiaries. So again, you're going to need to look at the trust's terms and instructions for how to distribute the assets. Sometimes real estate is going to go to a specific person, so that's going to require you to record deeds, file assessor forms to go along with that. Sometimes that means there's a reassessment of the property, sometimes it doesn't. Providing the necessary documentation to institutions to transfer accounts. Let's say there's a brokerage account and you're going to divide it up among 3 people. Then you're going to need to give them, the direction to do that. Maybe some people want to liquidate their share. Some people want to open up an account and have a transfer in kind. Those are the types of directions that the trustee has to give on behalf of the beneficiaries. And then if some of the beneficiaries are having their share held in trust, we sometimes call that an inheritance protection trust, continuing trust, then that is its own animal that we need to dive into. But basically, you're going to need some attorney help there because they're going to have this trust that's ongoing, that's going to need some care and maintenance over its lifetime. And you may be the trustee for that, or it may be someone else, but it is a process that has to be handled. Now, should you have a savvy lawyer help with dissolving and settling a living trust? Great question. And without professional help, it's going to, be easy to do something wrong. And I will say that we as attorneys see a lot of people come to us who have started the process of administering a trust on their own, and they run into a problem. And so then they're reaching out to us, and maybe things could have been a lot smoother from the beginning if they had worked with an attorney. And maybe they wouldn't have had to delay the administration. So without professional help, there's a lot of things that could go wrong. You could improperly account for the assets. Maybe you're not getting all of them included. You could get things like the date of death values wrong, maybe not get that stepped up basis that we talked about earlier. You could create tax disasters with retirement accounts, file incorrect property, documents. So working with an attorney is something that a trustee can do. And in fact, most trusts even give permission for them to work with a professional, and should do to make sure that they can go through a trust administration a lot smoother. And bottom line is the trustee has 100% personal liability for a trust administration gone wrong. So having someone help you through that process is key. We often, I think I mentioned this, but we have a lot of people that come in and they have done things not correctly. So we have to unravel and help them get things done correctly. And then lawyers help determine if the estate needs to go to probate or not. So when does the estate need to go to probate? If there is no will and no trust, and you have a certain amount in the estate, it's going to probate. You could have a trust that isn't funded correctly, or you could have only a will. Remember, in California, if you have only a will, you're going to probate. So we're also looking at some numbers here. I think in 2025, the threshold is actually 208,000. But if you have more than that in your name that isn't part of a trust, you're going to probate. And it's the only way that someone can actually take control of the property and then get it to beneficiaries. So here's our example. If the kids want to sell mom's house, but she's passed away, she can't sign the deed, the court has to appoint someone to sign for her estate. That's usually going to be your administrator, your executor. What's the number one reason trustees need to get a lawyer? Again, it's because that 100% personal liability for everything that can go wrong. There's a lot of horror stories out there, and you can get sued by beneficiaries if you're doing something wrong as the trustee. And so we do want to be careful and make sure we're working with a professional. What can the lawyer help you do? So back to some of those things that are important for the trust administration, we can help you find the important documents. If we've prepared them, then we likely have most of these things: the estate plan, the trust, the will, maybe an asset list. But we can also help guide you to find these things. So Property deeds, we can access those. Tax returns, filings, usually there's going to be a CPA that we're going to contact and get that information. Funeral instructions, those are things that are part of a binder if you've worked with us. But all of these things are important to have and be able to find. And we want to find all the assets. Again, their assets keep expanding, like the types of assets that you can have. And so here's a list again of some that are potentials, but there's cryptocurrency now, timeshares, the cash, all of those need to be identified, inventoried, and included for all the beneficiaries to know about. How do you contact a trust administration lawyer? Well, you can reach out to Cunningham Legal and get a free 15-minute call with our client intake specialist. She will help you determine whether you have a situation that requires a trust administration, a probate, something else. And then we also offer paid 1-hour consultations with the trust administration team attorneys to help guide you through. What does the trust administration lawyer do? We've touched a little bit on this, but we are going to guide you as the trustee. And every trust is, situation, administration is a little bit different. So in our consultation, we have to identify what are the pain points, what are the things that we have to work through to get this administration and get this trust closed. So a lot of the things that we're going to be doing are helping you with the identification of those assets, getting those valuations. So we're going to work with qualified appraisers. We're going to get a nice inventory of the assets together for you. We're going to review financial statements, and this is really important for a couple of reasons. One, we want to make sure we know what's titled to the trust and what's not. And then we also want to identify those assets that get that adjusted basis. And then we're also going to be able to consult with professionals, whether that's certified financial planners, CPAs, appraisers, and not only just real estate, but there's a lot of people that have personal property that needs to be appraised, like art, jewelry. Sometimes you're going to be working with mediators if there's disgruntled beneficiaries. So we have a wide professional network to be able to provide the services that your particular trust administration needs. We're going to also talk through the debts and the expenses. And again, when it's a situation where there's potential creditors, we're going to need to know about those and make a decision on what makes sense to do, validate a claim, and instruct you when to pay debts, especially taxes, because there's deadlines for when taxes are due, and we need to identify what those specific deadlines are for you. And then we'll strategize on reducing or eliminating estate and other taxes. So there's opportunities within the trust planning to make sure that we're going to use the appropriate trust or tax exemptions and credits. One of the big things that we help our clients with is portability. So when you lose a spouse and you are able to inherit their unused estate tax exemption, we can walk you through that process and we can help you. And that just adds more funds for your estate eventually when you pass away as the surviving spouse or your beneficiaries. Also, we can talk through Prop 19. And remember, this is a highly specialized practice area. We have many resources and webinars on Prop 19. But again, that is going to be that trigger of the reassessment upon a death that potentially we can avoid. Here's an example under Prop 13 of before the reassessment and after the reassessment. So you've got an assessed value of $200,000, and then if a death triggers a reassessment, you've got your assessed value jumping up to $750,000. You've got taxes going from $2,684 a year to $8,250 a year. That's a huge hike. So if there's a way to plan to avoid that for your beneficiaries, we want to be able to talk through that. And then we'll also fully administer the trust in conjunction with existing advisors. So I talked a little bit earlier about how we have a wide network to bring in partners to help, but you may already have people that you trust and work with, like a tax advisor and a financial planner. And we can all work together. And that really is the goal, for us all to work together to help get this administration done. And all those people are important through the process. It can be very complicated if there are complex assets. And so having the brain of the CPA involved, and also just the history maybe that the financial planner has with the decedent, it all comes into play and helps the administration process to be smoother. We'll also want to strategize on the retirement accounts. So those retirement accounts, whether they're going to a beneficiary or to the trust, we need to talk through what that implication is. There's going to be required minimum distributions. We need to make sure we get those done timely. We want to make sure that if there's inherited retirement accounts that need to get set up, that we help you do that. And there are very specific rules that apply in those situations. So here's an example of an IRA gone wrong at trust administration, when somebody is probably doing things on their own, thinking, great, I just inherited $1 million IRA and I'm going to withdraw it all. And you're going to see here in this chart that when you do that, you are winding up with potentially only $59,000 in cash, when you could have taken a different direction and had that stretch out longer and be a lot more profitable for you. So again, there are very specific rules. We want to make sure that if it's a non-spouse, that we're working with them to get that inherited IRA set up in a way that allows them to stretch it out for as long as possible. If the IRA is going directly to the trust, there's a 5-year rule to have that all distributed out. And so that can get complicated. And sometimes if the IRA is going to the trust, we can help you bypass the trust to have that inheritance go directly to beneficiaries. And then the distribution of the assets, again, the goal is to do that as quickly and as efficiently as possible, but also done correctly. So we need to interpret the trust terms, provide the notices, give the accountings, coordinate with the financial institutions, and potentially manage some disgruntled beneficiaries. And last thing I want to touch on today is subtrusts. So occasionally we are going to see in a trust that someone has their inheritance set up in a subtrust. If that is the case, we need to make sure that it's set up correctly, or that person that it was supposed to be set up for is going to lose all of that protection. So in our example, John wants to leave $500,000 to his financially irresponsible daughter, Sarah. And so we need to create a subtrust for that. And after his death, a trustee manages and wisely distributes Sarah's inheritance per John's instructions. So you've got your $500,000 that's going to be funded into this trust for the benefit of Sarah. And you have a trustee, likely not Sarah in this case, that's going to be managing for her benefit for her lifetime per the direction that you put in your trust. And we can help also with all of the final documentation to transfer the assets, whether it's deeds for real estate, again, helping to get accounts set up. Those are the types of things that we would help you with. So as we wrap up, before we get into the questions, I just want to remind you that we have offices in Northern California. Here's our list, in Southern California. And if you are not close to any of these offices, or even out of state with some kind of California connection, you can meet with us over Zoom, and we'll be happy to help you. Please remember to subscribe to our YouTube channel. This YouTube channel helps us, it helps you. Hopefully it's very informative, that you can see the weekly webinars pop up and learn more, share with your friends, so you can subscribe and like. And if you have any questions, I'm going to leave this here for call-in number, or our website has a lot of great resources. So if you ever need anything, you are welcome to call in